The next case is State of Ohio versus Christopher Byrd. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I will be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Thank you, Your Honors. Good morning. My name is Marie DeCola. I represent the appellant Christopher Byrd with Attorney Donald Malarczyk, and I would like to reserve 5 minutes for rebuttal. So I know this court is familiar with the procedural history of the case. The defense filed a motion to suppress evidence that was seized from a search of Christopher's residence pursuant to a search warrant. The defense argued to the trial court that the search warrant affidavit did not set forth probable cause, it was not particular, and a portion of the information relied on in the affidavit was stale. So starting with the probable cause argument, as our brief argues, the information in the affidavit largely relies on hearsay statements of unidentified, unnamed, confidential informants. The law permits hearsay testimony from confidential informants to establish probable cause, but only if the affidavit includes something about why the informant made the allegation and why the affiant believes the informant is credible. So we need, why did the informant say it? Why does the affiant think it's credible? And the search warrant affidavit in this case did not provide either. Our brief describes the 4 separate incidents or events in the affidavit that the affiant used to establish probable cause. The first paragraph is from September of 2022. The affiant states that the Medway Drug Enforcement Agency received information from a confidential informant, referred to as CS-1. The affiant does not state that he was involved in this investigation or observed anything for himself, so again, we're dealing with hearsay statements. The information that was relayed was that an individual named Quincy Byrd was selling drugs. We don't know who Quincy Byrd is, how he or she is connected to the informant or to Christopher, if they're related. There's no information provided. So we don't know who Quincy Byrd is, and Christopher's name, Christopher Byrd, is not mentioned in this paragraph of the affidavit at all. The affiant then makes a general statement claiming that the Medway investigators believe CS1 to be credible based on their past dealings with him. But the affiant does not allege to have any personal dealings with CS1 or any examples of CS1 providing credible information or any indication that this affiant did any independent investigation of CS1 himself to verify.
Didn't the confidential informant make controlled buys? Isn't that stated in the warrant? So isn't it beyond hearsay here? Isn't it a corroboration of the hearsay statements?
So the confidential informant in this case did conduct or did participate in controlled buys, but not with the appellant, not with Christopher Byrd. In fact, there's no controlled buys between any informant and Christopher Byrd in this affidavit at all.
What about at the house?
There's no controlled buys at the house, no surveillance done of that house. You know, the typical, indication that there's drug trafficking going on at a house would, you would think there'd be surveillance and traffic, human traffic coming in and out, things like that. A controlled buy conducted at that house, none of that happened in this case. The controlled buy is between one confidential informant, CS1, and Quincy Byrd, not the appellant in this case. So we believe that that is not corroborating evidence to show or to establish probable cause that Christopher Byrd is trafficking drugs in his house.
But the house that they got the empty box was addressed to Christopher Byrd.
Yes, and so a year later in 2023, the affiant talks about an unrelated search of an unrelated house that he did not conduct. A different law enforcement officer conducted this search. We don't know the circumstances of why there was a search of that house. In that search, there's a empty box found that is addressed to Christopher Byrd at the Catawba address. That's it. The box does not have anything in it. It's not tested for any trace of narcotics. There's no indication that there's anything suspicious in that box or anything at all in that box. And really that's the fourth, there's 4 events establishing probable cause. That's the 4th one. And that is the only event that ties Christopher Byrd to that house. And all we have is a piece of an empty box.
Where drugs were found, fentanyl and methamphetamine.
Yes, drugs were found in that house, but again, that was not
What
Christopher
about the
Byrd.
text message that the state mentions?
Yes, so there's, in this unrelated search, again, the affiant doesn't provide really any context as to whose house was searched, what the circumstances were, whether it was a drug investigation, but in that house, they, again, unrelated to Mr. Byrd and not the Catawba house, they find an empty parcel addressed to Mr. Byrd and text messages in the suspect's phone between allegedly him and Mr. Byrd.
Asking for ice cream, which the police say in the affidavit is correct.
Correct, yes. So again, this affidavit provides 4 events, and this is the only event named in that event, and this is from September of 2023. So a full year passes between the first 2 events that I've kind of described. The second event in 2022 is another controlled buy set up between CS1 and Quincy Byrd, again, not Christopher Byrd. The officer who observed or set up this controlled buy was not the affiant, so again, it's another officer telling the affiant about this controlled buy. It's not at the Catawba house, Christopher Byrd's not involved. And again, it's worth noting that at this point in the affidavit, the information is from September and December of 2022. And these 2 instances are between Quincy Byrd and CS1. No controlled buys took place between Christopher, and no controlled buys or surveillance took place at the Catawba house. And then you fast forward to 2023, where the affidavit speaks about a second confidential informant from Stark County. The affiant learns from a Stark County agent that a confidential informant provided information that Mr. Byrd was selling drugs out of his house. And this information from the informant is not verified. The informant's not identified, unnamed, no information about who they were, when they said this information, why they suspected drug trafficking at that house, no information. This paragraph also makes no statement about the reliability of that informant. It doesn't even say that the Stark County officer knew that informant to be reliable. There's no information surrounding the circumstances of that disclosure and no reassurance about who that person is. And then the last event, which we've already spoken about, is the unrelated search from an unidentified law enforcement officer where a empty package is found addressed to Christopher in the Catawba house. This is the first time that the affidavit ties Christopher to that house. The paragraph doesn't say that the parcel was tested for drugs or contained anything suspicious or anything at all to link it to criminal activity at that house. During that search,
Counsel, since we've talked a little bit about that, do you mind proceeding on with the staleness and particularity?
Certainly, yes.
I'd like to hear about those.
yes, so just to conclude the probable cause, in its order rejecting the probable cause challenge, the trial court held that the events described in the affidavit established probable cause because the information provided by CS1 was supported by personal observations and independent investigation. I believe that a reading of the affidavit does not support either of those contentions by the trial court, and accordingly, the trial court erred in finding that probable cause existed. So moving on to the particularity argument, not only did the trial court err in finding that probable cause existed, but also erred in finding that the affidavit satisfied the particularity clause.
Were there actually any computers or anything electronics that were seized?
I believe there were. I do not have the search warrant inventory in front of me, so I can't.
And what, if they were seized, what information was gleaned from them?
I don't know the specifics of that. Our argument is really just based on what was alleged in the affidavit.
Right,
Yeah.
but I guess the issue becomes for me, for one of the issues becomes, how does that impact? I mean, if you don't use anything, if you don't have anything, if there's nothing is seized, like somebody, if the magistrate issues a search warrant to search the garage and there's no probable cause, to search a garage at a residence, okay? But they don't end up searching the garage, what's it matter?
I see your argument, I see your question. I think in this case, or at least what we're arguing, is what matters is what the affidavit said or didn't say. So it's before we even get to the search, we're focused on the four corners of that affidavit and whether or not they satisfy the requirements to allow them to even conduct that search. So we're alleging that they did not even jump that first hurdle. And specifically in this case, the particularity clause, our argument is that the paragraph 4 of the search warrant lists the media or the electronic devices that the officers were authorized to seize at the house. The search warrant authorized seizure of computers, electronic tablets, removable hard drives, storage devices, cell phones, and cameras. The warrant failed to limit the amount of electronic information to be seized from those devices and did not limit it in any way. There's no time frame specified as to the, when can the data that's inside of the computer, the time frame in which that's to be searched.
I'm going to go back to my question because everybody relies on Castagnola. I never can say the word. I've been on the case a million times. I was a judge on the case for I don't know how many times. Anyway, the point is, in Castagnola, the whole point was they got the search warrant and the particularity issue was reversed on the Supreme Court because of the fact that they got the search warrant and they asked for the computers and everything, and then they filed child pornography. And all the computers were related to the only reason in the search warrant for the particularity requirement for, the limitation in the search warrant was in regard to an offense of throwing tomatoes, eggs at a police officer's home, and so that seems like such a different circumstance than we have here.
I agree the facts of that case and the facts of this case are different, but I think the language in the affidavit from that case, and I'm going to say that case because I also have a hard time pronouncing it, from that case and this case, are the language between those two affidavits is really the same. The Ohio Supreme Court in that case said you cannot just generally allow officers to seize or have discretion in seizing any electronic that they find without any limitation on that.
Well, how else would this be more particular? That same paragraph says receipts, ledgers, drug trafficking. I mean, what else could they write if they were trying to find those things on a computer? I don't think people handwrite things much anymore.
Right, and it's a good question and it's a tough question. And it's a question that I defer, the wisdom of this court to answer. Today, I don't have the answer about what the magic words are or what the limitation is that would be acceptable. All I know, or all we know, is that the Ohio Supreme Court has warned about what's not acceptable. And that is just a general blanket authorization to allow law enforcement discretion to determine what they want to take and what they don't want to take. And the way that this is worded, as the Ohio Supreme Court warned, is if you're leaving the officers a chance to obtain something that should not be, an electronic that should not be or is not involved in this case, there's a problem.
And you're heading into your rebuttal time.
I'm going to briefly talk about staleness. We believe that the trial court erred in finding that the 2022, the first two events were refreshed by the second two events in 2023. The 2022 events are controlled buys between Quincy Byrd and CS1. The 2023 events are between a second confidential informant that we don't know anything about and a suspect in an unrelated drug investigation. I think definitionally, these are different players, different incidents, totally different circumstances. I don't think that the 2022 events can refresh the 2023 events, considering how different they are and who they involve. So for all of these reasons, we ask this court to reverse the finding of the trial court and remand the case back for further proceedings consistent with that decision. If there's no more questions, I'll reserve the rest for rebuttal.
Thank you.
Thank you.
May it please the court, Heaven D. Martino, on behalf of the state of Ohio, we are asking that this court affirm the trial court's decision denying the appellant's motion to suppress. With regard to probable cause, the affidavit, and this is a four corners argument based on the affidavit itself for the search warrant. There are two events that occurred in 2022 and then two events that occurred in 2023. The first event involves a indication from a confidential informant that they got information that Quincy Byrd was selling meth. On December 8, 2022, that confidential informant engaged in a control buy with Quincy Byrd. And Quincy Byrd told that informant that a white car was going to be bringing the drugs. And a white car did bring the drugs that were purchased in the control buy, and that white car was registered to Christopher Byrd, and the driver of the vehicle, according to the search warrant, paragraph 10, matched the description of the registered owner of the vehicle, which would be Christopher Byrd. Then, about a year later, those same items were then refreshed when the police officer obtained additional information that Christopher Byrd was a person who was a source of methamphetamine. There was a notification in the affidavit that Christopher Byrd's brother had sold drugs but had been arrested. Then the police obtained a search warrant. The search warrant is not included in the affidavit. It would not be properly challenged here. There was a search warrant that was executed on another home of another individual. That residence is named in the search warrant affidavit. The homeowner's name is listed in the search warrant affidavit, so it is in the record. It is not an unnamed person that we don't know who it is. When they executed the search warrant at that individual's home, they found drugs, drug paraphernalia, the package that was listed out to the address of Christopher Byrd with Christopher Byrd's name, and they also obtained text messages to Christopher Byrd from that named individual whose house was searched pursuant to a valid search warrant, asking for ice cream, to hurry up with ice cream. He was very hungry for ice cream. And then there's indication in the affidavit from the affiant that ice is a code word that is used by folks who are purchasing drugs to indicate that they're purchasing meth. The affidavit also contains a lot of information about this police officer who's been with the Akron Police Department since 1999, has specific training in drug interdiction. They talk about the confidential informant and how that confidential informant had never given any false information, that his information in the past had been corroborated. The officer talks about knowledge of how drug sales and drug trafficking, how that works, the way that those drug traffickers will keep ledgers on their electronic devices, that they might delete them, but it can still be on the hard drive, that drug traffickers usually have firearms, and then based on all of that information, asked for the particular things to be searched and the particular places to be searched. This case is completely different than Castagnola. That case involved first a search warrant that usurped the authority of the fact finder by including an inference that was not actually in the reported statement by the confidential informant, which was that Mr. Castagnola had looked up a prosecutor's address online. And the Supreme Court first said that that was the error that got the whole ball rolling, because that took away the fact finder's ability to decide if in fact anything had been done online, which is why there was the ability to look through the computer for the information which would have been intimidation evidence. And with regards to the particularity, the Ohio Supreme Court said that information was not clear enough because it just said evidence of intimidation. And it didn't give the person doing the search of the computer or the cell phone or any electronic devices a real clear indication of what they were looking for. In complete contrast here, the affidavit gave a very complete view of what they were looking for. They were looking for evidence of drug sales and drug trafficking. And the officer explained that that could include ledgers, and that oftentimes when people have large amounts of drug sales, they try to hide that income by putting it into something legitimate. So this case does meet the particularity requirement. It does meet probable cause. And the evidence with regard to the two incidents in 2022 that are arguably stale would have been refreshed by the new information that came to light with regard to Christopher Byrd being a source of methamphetamine, and then his name and address being found on a parcel in a house where drugs and drug paraphernalia were found, in addition to the text messages that contain code that the officer testified to is consistent with the sale of.
Counsel, I'm going to interrupt you, I apologize, because we have limited time, so.
Yes.
Did the officer in the affidavit actually say ice cream was code for methamphetamine, or did he say ice?
He said ice, he did say ice.
That's what I was wondering.
And articulated that they talk in code in general.
Sure. Then the second thing in regard to what was seized, do you have information as to what was seized? Were any computers or any electronic devices seized?
I do not have the inventory in front of me either, and I only looked at the four corners of the affidavit because that was the argument. I would have to assume there were electronic devices because that is what they were arguing to keep out, but just based on the record before us, I did not look into that.
So the limitation you're saying is in regard to the particularity argument is because it was limited to ledgers and what else was it?
Ledgers, who they might be selling to, the officer went through the type of things that a person who was selling drugs might keep, which would include information as to when they entered like the sale of something or the person they're selling it to, so they could help determine the chronological order of events, where somebody may have accessed the computer, which might put them at the location of an event. So all the things that could corroborate not just the name, the amount, the item that was sold and purchased, but also the location where that may have occurred, the mental state that may have gone into that, what could have been deleted, the reason why it would have been deleted. So he explained all of that and the way that records are kept and are often attempted to be hidden from the police, and the way that drug traffickers would try to hide that.
I'm just wondering in regard to that because App.No was one of the first cases that really dealt with seizures of the search warrants and the seizures of computers. And one of the huge, concerns that the courts had and still have is the computers are not like what we used to have. Everything now is just a cell phone, even that everything, your whole life is contained on a cell phone. So I understand your argument about the limitation, but at the same rate, you're still going through, it's not like a drug dealer is going to say, here is the file on my drug deals.
Correct.
Or I would hope not, anyway. So you're still going through everything possible.
Correct. You'd be going through potentially whatever could lead to the drug sales. And with regard to that, if the officers found something else, then they would have to get a separate search warrant. But this is not some unbridled, go through everything. The officer explained what he was looking for, the basis for why you would be looking for those things, and it is just, I guess, a modern day problem that we have so many things on our phones and our computers that while they look for that, they may come across something else, but they should be doing searches that are based on, names and locations and drug sales, and not finding that other information.
I guess what I'm asking though is, and probably a very bad way, is what is going to be the limitation in respect to, you could almost tie a computer, because you keep your whole life on your computers, on your phones, you could almost tie that to any crime then when you're asking for a search warrant.
Which is why in this case, you have to be particular about what is the crime you're investigating, what particular evidence are you looking for, and then how would that evidence relate to this particular crime, which the officer did. In App.No, they did not. They said any evidence of intimidation and did not say specifically the address of the prosecutor or what, purchasing of eggs or whatever might have been relevant to that unique situation. That was not in there. And the court would have never even gotten to that point if they hadn't gotten to that first prong, which was that there was that inference that usurped the magistrate's ability to decide the probable cause determination. So I have not seen any other case where the language that was used in this particular search warrant has been held to not be sufficiently particular. As you mentioned, App.No, that case is over a decade old at this point, and there were initial concerns with regard to particularity, but this one is narrowly tailored enough to put the person doing the search on notice of what they're looking for and the reason that they're looking for it. It is easily distinguishable from App.No, but I do agree that the language in App.No and the concerns in App.No are ones that are worthy of always revisiting to make sure that we're not just giving unfettered access into electronic devices, because people do have a lot of information on there. But in this particular case, the information was not stale, it was refreshed by the current information. There is probable cause contained within the four corners of the search warrant, and the search warrant affidavit contained particular information with regard to what was being searched, where to look for it, and the reason that that information would be relevant to drug trafficking and drug possession in particular. No further questions addressed in my brief. Thank you.
You have about 4.5 minutes.
Thank you. Revisiting one of the events from 2022 where Quincy Byrd is observed by an officer, not the affiant, speaking to the driver of a vehicle, and that vehicle was registered to Christopher Byrd. The affidavit says that the description of the driver of that vehicle matched the description of the owner of that vehicle. I think it's worth noting that no positive identification was made of Christopher Byrd, and no observation was made by the affiant in this case. CS1's reliability was verified by an officer that was not the affiant. And the second informant's reliability wasn't verified by anyone. So these hearsay statements can only be relied on in an affidavit to establish probable cause if the affiant affirms that that informant is reliable and does some sort of independent investigation to verify that. And the affiant did not do that in this case. Going to the particularity and the language of the search warrant in Casagnola versus the search warrant in this case, they're both search warrants are authorizing the seizure of electronics related to the crime that's being investigated, respective to both cases. And in both cases, the language does not limit the data or the electronics and the data on those electronics that can be seized. It entirely left it up to the officer's discretion to seize. And the Ohio Supreme Court in that case warned that whenever an officer has the discretion and could potentially seize an electronic or information that is not a part of the investigation, then there's a problem with the search warrant. And again, it's a tough question. I don't know what the magic words are, how it should be limited to satisfy the Ohio Supreme Court's requirements. I just know that in this case, the search warrant affidavit did not do that. The affidavit does not provide probable cause to believe that drugs were being trafficked at Catawba. There's no surveillance of that house. There's no surveillance of Christopher Byrd. There's no controlled buys between Christopher Byrd and any informant, or any controlled buys taking place at the Catawba residence. The fact that an empty box was found in an unrelated search is not enough to establish probable cause to believe that drugs are being trafficked at the house on Catawba. For those reasons and the reasons I stated in my argument, we're asking this court to reverse. Thank you.
The court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision on the day it's released. Also, the opinions are posted on the Ohio Supreme Court website. Thank you both for your presentations.